issues to be dealt with, and people are grieving and they're doing things in their own time, in their own process, and it can take quite a while for people to figure out what's going on.
Yeah.
I've actually had problems too with financial institutions. It's not so much a case where we have a family that's inheriting the assets, but when you have a situation where maybe the person didn't have any immediate family, it can be hard to find out who the beneficiary is because the banks are not allowed to disclose information.
Oh boy.
And so we've run into problems. I have a $250,000 account that my client, who's the successor trustee and is responsible for distributing the little bits that are in the trust, this is outside of the trust. And the bank won't talk to her to let her know who is the beneficiary that's named on that account. And so it can become really difficult to get some of this done, which is part of why you need to start early, because we may need to go for a court order to force the bank to produce the records.
Okay. So you've sort of brought up a good point. Who is responsible to be sure of the administration of a retirement account is handled in a timely manner?
Who is responsible? Well, the question is going to, it's the person who is the fiduciary or the trustee is going to be wrapping up the decedent's affairs. So they're going to be responsible for making sure that the decedent's required minimum distribution was made for the final year. They're going to be responsible for making sure that the appropriate values are included on an estate tax return. Typically, when I'm representing the trustee, we include that as part of, following up on that account as part of making sure that the entire estate is fully administered after death, because we don't want loose ends hanging out there.
Right.
But when you're talking about my decedent's retirement account is going to her sister, and the rest of the estate is in a trust and going to the children.
Yes.
The sister knows about the retirement account, and the sister takes no steps to collect that account, and therefore she misses her own deadlines for making her own distributions. That falls on her. Okay, so my trustee or the a representative of the estate is going to be is technically responsible for the distribution for the decedent's final year and for valuing it for the estate tax return. And if it comes into the estate or comes into the trust, they have responsibilities there also.
Okay. I'm kind of afraid to get into some of these other questions. So let's see here. Well, here's one that people probably would like to know about. So once an account's been inherited, are the contingent beneficiary designations still effective? So I leave to, let's say, to my wife, and I say, if my wife predeceases, if my wife predeceases me, then the contingent beneficiaries are my children. Okay, well, I pass away, my wife's still living. Now, if something happens to her, does the account going to go to my kids automatically?
What should happen after the IRA owner, called the participant, dies, is that the beneficiary should notify the account holder, and then the account is transferred from the participant's name to a new account called, decedent's IRA inherited by wife. And then wife fills out her own forms as to who the beneficiary is at her death. So she fills out a form and says, my new husband is the beneficiary of anything that's left in this account.
Yes.
And then it would go, when she died, to that named person.
Yes.
Let's say you passed away, your IRA says your wife is the beneficiary, but a month later, before she's even begun to process grieving your death, and therefore has not gotten to all this paperwork, she's done nothing with the IRA because it's only been 30 days, she's hit by a car and she's killed. The question is, does it now go to your children because that's who your contingent beneficiary is? No. No. It goes, if she has not designated who it goes to subsequently, it vested in her the moment you died, even though the paperwork hadn't been done to transfer it, it vested in her the moment of your death, and therefore it is distributed pursuant to her estate. And if she says, and if her existing estate says that if my husband's not living, everything goes to the Red Cross, then it goes to the Red Cross.
Yeah. Now, it may be that the plan also names some family members. In other words, it may say it goes to the kids if the person is deceased and they haven't named another beneficiary.
Correct.
So you have to find out what the plan says.
Every plan has their own contract. Each contract is different, and many of them do have contingency clauses in there.
Okay. All right. Should a surviving spouse immediately roll over or convert an inherited IRA or retirement account to his or her own name?
Well, the example we just used points out some of the benefits of taking care of doing that in a timely manner, but typically we wouldn't just rush out to do it, particularly if the surviving spouse is younger. If the surviving spouse is not yet 59 years old, 59 and a half, and they take that inherited IRA and follow their financial institution's generic instructions, which is if you're the surviving spouse, you want to roll it over, and they roll it over into their own IRA. Now it is not an inherited IRA, it is their own IRA. That's what a rollover is. Now it follows the regular rules for an IRA, which means that this young surviving spouse cannot take out distributions without being hit with the early withdrawal penalty.
Right.
When your surviving spouse is younger and you've lost, say, the husband or even the wife, whoever it was that passed away, you've most likely lost a wage earner. Mm-hmm. And most of my cases where I have a younger spouse, it is really critical to not do a rollover because the surviving spouse is unfortunately going to need the possibility of getting into those funds to pay for college, for support, and for other things going on. And we certainly don't want them to be hit with a 10% penalty that could have been avoided.
Right. So one thing that people need to be aware of related to this is you can always convert it later.
Yes.
So you can take the account, put it into an inherited account. So Jane is beneficiary for John Smith or whatever, mm-hmm. however you're going to title that, and then take the distributions because basically you're taking them as a death benefit, and that qualifies you to take it out earlier. But then, now you're over 59 and a half, now you can safely convert it to your own.
Exactly.
Not a problem.
Exactly. Gives you a lot more options if you don't run out and convert.
Okay. Now, say you're a beneficiary of a retirement account. Why don't you just cash it out?
Woohoo! And get the red Ferrari, right?
Frankly, I think that's what an awful lot of people do, but why should they think about
unfortunately, or fortunately for the car dealers and for those of us who love cars like that, so that IRA account is subject to income tax on withdrawal. So the purpose of the IRA account for the original owner was to have assets to be utilized during retirement. If they died before needing all of those assets, fabulous. They were able to pass them on to you. A nice big gift that they can give you is you can defer recognition of that income. If you pull out $5,000 from the IRA, that's $5,000 of income added to your own income, which is going to be taxed at whatever rate you're at. If you inherited a $250,000 IRA and you withdraw $250,000, you have just increased your personal income by $250,000, and you're up at a high tax bracket, and you're going to lose all the benefit of the compounding that you could have had if it stayed in there and grew tax-free and you took it out over a long deferral period.
Okay.
Patience pays off.
Okay. I have an inherited IRA. can I convert that inherited IRA to a Roth account? Everybody's talking about Roth conversions and how great it is. Can I do that?
I'm not sure. I don't think so. I don't think inherited IRAs
So
are
I baited you.
options there. You did. Because,
Yeah.
you know, honestly, I have talked with so many clients since they relaxed those rules, and I have not been able to talk a single person into paying a dime of extra tax now.
I have.
Good for you.
So
You are the salesman, and I think it's a great option.
Yeah.
So what is the answer on
The
that
answer
question?
is that you cannot directly convert an inherited IRA to a Roth account. Okay, but here's the second question. What if a person has an inherited retirement account at work, a 401k account that the decedent had? That can be converted to a Roth?
The answer must be yes, or you wouldn't have pointed
You're
it out.
right. So there's actually a fairly recent law change, and actually, I will say there was an IRS ruling that came out. And basically what it says is, yes, you can convert directly from an employer, like a
Sponsored
401k
plan.
account,
To
a Roth account. But don't go to the IRA and then to the Roth. That won't work. It has to be a direct conversion. So see your tax advisor, but it's a great new thing that's out there. Okay. Let's see here. So hit that. I don't want to get into that. How about let's talk a little bit about an issue that you talk about from time to time, and we just have a very short time left. So it's a little unfair. I'm sorry, but what about a Q-tip? So a marital trust.
correct.
Okay. Is there a problem as far as getting money out to the surviving spouse with that? You know, and I'm referring to Uniform Principal and Income Act and that sort of stuff.
Okay.
Comment
So
about that a
of
little
course we know that under the federal estate tax laws that when you leave your assets outright to your spouse, you get a deduction for that, so it's not going to be subject to estate tax. If you don't trust your spouse, or it's a second spouse, and you want to tie it up, or you want to protect it for remainder beneficiary, so you put it in a Q-tip trust. It's a special trust that provides the spouse gets all the income, but maybe none of the principal. My issue with those is that under the Uniform Principal and Income Act, those required minimum distributions that come out of the IRA and go into the Q-tip trust, 10% of that is considered income, and 90% of that is considered principal. That's the default rule. It's very, very critical when someone's doing their planning to explore what their personal definition of income is, so that if they thought that the IRA was going to let the entire required minimum distribution go to the spouse, that is in the document. Otherwise, the default rule applies, and the spouse will have much, much less support than the person anticipated.
Okay.
That's one
Naomi,
piece.
we're all out of time. So thanks again for
Thank you,
being my
Mike.
guest.
You're welcome.
Folks, this is a huge area, as you may gather. Hopefully giving you something to think about. Certainly see your tax advisor, see your estate planning attorney, and so forth. And
your financial planner.
And your financial planner. And we'll see you next time on Financial Insider Weekly.